Well, the rise of Afrobeats and other Nigerian sounds have actually come along with once upon a time. A lot of people in the entertainment industry and in parties and social circles may not even want to touch the sound coming from some young Nigerian artists. The music business in every part of the world is complicated and is something unusual in our everyday world. Many artists basically hardly understand the dynamics of what's at play, and at what point in time should you be putting pen to paper to analyze and actualize some of these talents is something that we'll be discussing today on The Square. Welcome to The Square. I'm Sulaiman. There have been several conflicts between record labels and artists. Many Nigerian musicians are solely focused on the talent part of the business and don't show great interest in the details of the dotted lines they sign. Music contracts are usually complex. They contain vital information which may be between the lines. It takes a professional eye to see these details. But most artists who either lack an understanding of the expectations and the statements or are just too excited to read through sign contracts that eventually become a problem. There have been a number of cases in the past, with some of the most popular involving Vector and YSG Entertainment, Bribo and Chocolate City, Cynthia Morgan and Northside Records, Keys Daniel, once upon a time Kiss Daniel, and G Worldwide, and of course Two-Face Idibia, now Tubaba, and all of that. Perhaps you may not understand why the name change, and we'll be breaking all of that down pretty much later today. It's a business where there is enormous potential for life-improving contracts. There's also the risk of life-damaging agreements. We'll take a moment and we'll be meeting our guests. But first, Kemini is here with me again. Kemini, good to see you.
Good evening to you, and good evening to you, Sulai.
Well, for the first time in a long time, we're trying to look at what's happening, what's at play here, and it has to do with our talents on the continent, especially now that they have in collaboration with people, other artists from outside the continent.
Yep.
And even within the continent, they have been shortchanged. And we decided to say, okay, wait a minute, let's get the experts to come speak on these and perhaps make them understand that this is big business, and it's a business that should also involve a team of experts that will help you analyze and look through the fine details before you put your pen to paper.
Absolutely, and this is one of the shows where you say, go check on your favorite artist to watch the show, because there's going to be a lot going on tonight, right?
All right.
And this conversation is not just Nigeria specific, because the problem is across the continent, especially now that the world is very much interested in African music. And so the world is coming to us, and we are also going to the world. So your favorite artists everywhere in the world should be watching Village Square Africa tonight.
And we'll take a moment. When we come back, we'll be speaking with Tilewa Oyefeso, who's partner Wigwe and Partners. He supervises the entertainment and corporate commercial arm of the firm. And pretty much later, we'll also be joining Luda Oruye, who's a talent manager. Well, a lot on the plate today, and of course, Tilewa Oyefeso joins us. He's also Chartered Secretary, Chartered Mediator and Conciliator, Chartered Secretary, Institute of Chartered Secretaries and Administrators, and Associate of the Institute of Chartered Mediators and Conciliators. And he was once, should I say, you were once in a bench?
Yeah, on the lower bench.
Well, he said he was once a magistrate. But again, we're looking at the legal framework of music business in Nigeria. Now we're smiling, but some of these artists can't actually put a smile on their faces, knowing full well what actually could go down. What can you say about the current understanding first of music business in the country, specifically by practitioners, in this case, the artist?
Great. First of all, it's great to be here. Thank you, Sulai, and thank you, Kemi, for having me today. It's a very interesting conversation and a continuing conversation at that. Very brilliant question you've asked there. And I'll just start by saying that there's a lot of ignorance, out there about, the music business and the framework and structure for, the music business as it is. So because of this lack of understanding and awareness by the protagonist, particularly the up-and-coming artists, a lot of them end up signing contracts and their fingers get burnt. And this is a phenomenon that keeps happening, on a daily basis. So for me, the starting point is to really understand the history of the music business, particularly within the confines of the legal dimension to it, because law is life and is science.
So there's a legal dimension
There's
to
a
this.
legal dimension to
A
this.
lot of people don't know.
Absolutely, absolutely, absolutely.
What are the things that people are misunderstanding the most when it comes to this legal dynamic that you've spoken about?
Thank you, Kemi, for that question. First and foremost, if you consider Section 1 of the Copyright Act, it talks about the categories of works that are eligible works for copyright. And essentially, musical works and sound recording, they are elements. They are part of these 6, eligible works for copyright. But you see, for the ignorant minds, they do not understand that there's a whole lot of difference between musical works and sound recording. So it's this lack of understanding that forms the basis of the contracts that a lot of them sign. At the end of the day, the standard clauses and boilerplate clauses in these contracts, they fail to understand it, and they end up signing a bad deal. And it gets very sour and unsavory for them, and they begin to lick their wounds. So that's just one of the facets. So essentially, you have musical works and you have sound recording. If you have a composition, you're an author, you have authored your work, that gives you some eligibility to claim copyright over the composition. Then sound recording is a different kettle of fish entirely. So sound recording deals with your masters, meaning that you have copyright in sound recording, then you have copyright in musical works. But another snag is that within the framework of the law, particularly our own Copyright Act of 1988, it doesn't really classify musical works as composition. It was the 1992 amendment done by the military regime that actually introduced the expression composition. So we have a legislative framework that is not so airtight. And at the end of the day, a lot of people just keep chasing their tails in circles because of their failure to really understand what the law is, how the law is structured, and how their intellectual property rights are to be exploited. And the failure to understand that is the cause of the brouhaha and, the unsavory consequences all over the place today.
But if we look at the copyright law at the moment, in terms of its utilization within the industry, what would be your reading into how it's being utilized, among musicians?
Great. Let me draw inspiration from Oliver Wendell Holmes Jr. His lordship had said at a point in the case of Herbert and Shanley that if music would not pay, then I should give it up. Because music essentially is a full-time job. So you can't just go into music or the music business with a faint heart. Kanye West recently just said, if you're an artist, you should see yourself as a CEO. You're a chief executive officer, meaning you're a businessman, you're an entrepreneur, because of the many facets, of music and the music business. So in terms of the utility, my reaction to that is that, we need to, bridge the knowledge gap. The lack of understanding, the ignorance is a major problem, and it's a dilemma, having a deleterious effect on these artists, because we need to really enlighten them and educate them. That's the reason, some of us, as lawyers that have this understanding are out there as white knights to help them out.
Right.
No, I'm trying to look at the journey so far. Even you were trying to take us back in time, but looking at the journey so far and where we are at the moment, there's hardly any country, specifically in the UK and the United States, that you don't get some states or cities where African music are being played. We've also seen collaborations between Nigerian artists and foreign artists. Now, help us make sense of how such contracts can actually be of benefit to these young Africans.
Great. That's a very sound question, Sulai. First and foremost, let's look at the existing structure that we have here. We have performance rights organizations that have become completely moribund. These are the collection societies that ought to be responsible for, intellectual property exploitation of these artists, rights. And they are the ones that should be in charge of collecting revenues for these artists, for a lot of their works, that are being performed outside the country. For instance, Nigeria is a member of the Rome Treaty or Rome Convention, and that allows artists to be eligible for neighboring rights. For instance, neighboring rights are rights, that you enjoy where your music is played outside your country, and you're entitled to collect royalties for, such performances. I cited Oliver Wendell Holmes in Herbert and Shelley. That was the history. That was what happened in that case. And he said, if music would not pay, then let's give it up, because music should pay you if you put effort into it and you produce something. It's work. So if, for instance, like a Kiss Daniel song is played in a pub or in a restaurant or somewhere in the UK, the US, he's supposed to earn royalties for that.
And they're earning that now?
Now, that's a complex, it's a complex question, because we need to understand the background. For the legacy artists, the A-list artists, it's a different story compared to the other younger ones. That's the ones that are isolated, that are trying to, to bring themselves up and, give themselves some niche. So for those ones, it's a non-starter.
So it's more like free publicity for them. So you should be happy that your song
I tell you,
is getting
airplay. I tell you.
But, trying to bring this, I know a lot of people would not forgive us if we don't bring this into play. And I know we'll dig into it, but, there are quite a number of talented artists. And just as they were having, a cult following, you woke up someday and there is a name change, either in spelling or, for instance, you just mentioned Kiss Daniel. Once upon a time, we knew him as Kiss Daniel with a double S, and now it's a double Z. So perhaps something legal actually went on there.
Sure, definitely. Now that's a result or a resultant effect of the type of contract he signed with his label. Now that's another dimension to it, because when you're dealing with harnessing your copyright or your intellectual property works, you need to understand that you have the artist and repertoire on the label aspect of the deal and the publishing aspect of the deal. If you have a record label that wants to sign you up, they get to sign a contract with you, a recording contract, and they put a lot of bogus clauses in there that if you do not, have a sound lawyer by your side to review these deals, you just end up bungling it. And at the end of the day, you bite your fingers. So essentially, probably certain rights were mortgaged and some guys were double dipping. And all of a sudden, let's use that word, you now blow out and everybody wants to collect something. So it now becomes a question of who gets what. This is what you signed, so we're coming after you. And if you do not have that clout or that grace, like some of these A-list artists have, you won't be able to survive.
Do they have legal teams? Do they have lawyers, in their teams? I'm talking about pockets of artists that we have in Nigeria and in Africa. When you have in your team a sound man, a manager, and even security, shouldn't they also be thinking of having a lawyer?
That's very vital. My position, it's a position of finality on that. Before you set out at all, you must have your lawyer by your side. Your attorney must be by your side before you speak to anyone. But the question is, you have to get a competent lawyer at that, because it's not just any lawyer that understands, the intricacies of the music business and the workings of the industry. Because we have lawyers that specialize in several areas, but there are some very good ones that are specialized lawyers and understand, the workings of the industry. If you're lucky to get any of these guys, then I tell you from the word go, you're going to get it right.
So for those who cannot afford lawyers at the very beginning, I mean, those who are there now at the top do not have an excuse.
Especially those we call the upcoming.
Yes, who cannot afford lawyers at the moment. What should they look out for in contracts?
Okay, great. For those who cannot afford lawyers at the moment, my take would be that essentially music can be subsumed within the cultural and creative industry. And a lot of young people out there now, they should get their focus right when they're on social media. They should look out for events and activities that will educate them. A lot of law firms, they do seminars, they do publications, they write articles. You should pay attention to details. When you see such articles, you could get the light in such articles, rather than you just going on social media and engaging in frivolous activities, as many of today's young people do. So they need to get some education, because you have the knowledge base. Once you build the knowledge, then you begin to ask the right questions, particularly for the up-and-coming ones. A lot of them just believe it's all about talent. Oh, I can sing, listen to my song. Oh, some guy has called me, he wants to manage me, and just end up signing, a wrong deal, and it gets ugly.
Right. So for basic knowledge, I know this could be much more nuanced, but are there types of contracts in the music industry? Like, what would they be? Oh,
very much. You have several contracts depending on the layer. For instance, if you're a label outfit or a recording, if you have a label outfit that is trying to sign you on, you get a recording contract signed. In that contract, you have several clauses that will deal with your master's recording, that will deal with your mechanical royalties, performance royalties, merchandise, what have you. So essentially, some of these clauses are there that your lawyers would interpret for you so that you don't get it mixed up. So you also have management contracts you sign with, like a manager. You have talent managers too that will come in and tell you, okay, look, you have this talent and I can help you. I can help you, source deals. I can introduce you to, major record labels and get deals for you. So from the word go, you have a management contract where you need to look at some very specific clauses like, exclusivity. What's the scope of the authority of this manager? Are you having me as your only artist, or you have several artists? How much time are you going to invest in me? So you need to understand these specifics. You need to understand the details. So these are some of the highlights.
I'm just wondering how many new artists could ask such questions.
Yeah.
People to ask such questions, especially when you don't have a lawyer by your side.
Because, because one of the issues that we also have to look at has to do with that phrase, rip-off. And if we tie that to record labels and also tie that to managers, it would seem as if sometimes these record labels, specifically some foreign record labels, now looking towards Africa, looking towards Nigeria, perhaps they understand that some of our artists may not have idea or knowledge of the legal details involved in the entertainment industry. Have you been able, in your own, practice, uncovered some of these experts who are out there to rip off the young talent?
Oh, great! That's quite interesting. Well, in my experience, we've had course, we've had course to work with some of the A-list artists, and it was quite some experience for us. What I'll tell you is this. At the moment, we have almost a non-existent legal framework because our laws are obsolete and almost completely irrelevant. You have a Copyright Act of 1988. You have an amendment 1992. Then you have a draft bill 2015 that is trapped in the closet. The policymakers don't know what to do with that. So at the moment, we do not have any strong legal framework that can serve as an instrument of protection for these young people that can, help them and protect them from, these scavengers and these new classes that come into the country and sign contracts with people and eventually rip them off. So essentially, the policymakers need to, step up the game and up the ante by, giving us the robust legislative framework that is needed, that will provide that, protection and that base for the young people. I'll cite an example. In the United States, they have the MMA 2018, which, it has already been passed into law during the Donald Trump administration. Now, the Music Modernization Act is a very comprehensive and robust legislation that takes care of, the artists, both the legacy artists, the young artists, and the old artists that have retired, to ensure that a lot of them are being compensated for the work that they've put into their craft.
Okay, let's take a moment and bring in Luther Oruye. He's a talent manager. Luther, good to see you, and thanks for your time. And I know you've been listening with rapt attention. We wanted Tilewa to set the foundation for this conversation. Let us in on your experience so far, especially in managing some talents, without giving any name, if that is fine by you. How healthy has it been, speaking, of which Tilewa has highlighted that it doesn't look as if these talents understand the importance of having a lawyer.
True. Good evening, everyone. Thanks for having me, first of all, Sulaiman. It's been very interesting up to this point, and I've enjoyed every bit of it. First of all, he's actually right, because a lot of talents nowadays don't really understand the legal frameworks involved in the music industry, because it's actually confusing in a way, explaining to an artist that he needs a lawyer to look at every contract. He doesn't really understand what it means to go through contract. Why is he signing a paper when he can just sing and be okay with it? Why does he have to get that complicated is what usually confuses them. But for talent I've managed, the first thing we do in my company is, and also everywhere else I've worked, is to hand the talent a contract. And from all the studies we know as talent managers, talents are meant to have lawyers before they even approach a talent manager. You should already understand that when you approach a talent manager, he's going to hand you a contract depending on the status he is in the industry. He would charge certain percentages ranging from
Luther, I think
it looks like we lost
have a
Luther.
glitch. Yes.
We lost Luther there, but let's talk about collections, Tilewa. How strong is collections in Nigeria?
That's a very, very fundamental question, Kemi. And I believe that's the hot topic. Talking about collections, I'm sure you're aware of the controversies, COSON, MCSN. We have a dilemma there. There's a Supreme Court decision that recently, emphasized on the rights of MCSN, that's the Musical Copyright Society of Nigeria. And that if you really study that case law, that authority, you realize that the Supreme Court did not really delve into issues that border on administration of copyright, collection, rights of artists. It was an isolated issue that bordered or focused on the locus standi principle. That's the right of the Musical Copyright Society of Nigeria, to act as, a collection or, a collection society and all of that. So at the end of the day, we had COSON, the legacy COSON that had been in the business for so many years, and MCSN struggling, unlike, COSON that had covered a certain degree of mileage. So the decision comes out and MCSN says, oh, we are the boss. COSON, we'll show you the door. COSON's license got suspended. The NCC, the Nigerian Copyright Commission, did not renew the license of COSON. COSON is under some investigation. Now, MCS said it's more like a baby that has just been put to bed because COSON over the years had signed reciprocal agreements with several countries all over the world. Now, talking about neighboring rights again and the ability of an artist to really get reward for his labor. So in terms of collection, we are absolutely weak as a nation. When you consider the strength of our number in terms of demagogy, Nigeria should be at the forefront. But when you look at Africa as a whole, we are lagging behind because we do not have a strong framework and we do not have, these collection organizations working effectively, to engender and prosper the artists.
Okay, Tilewa, I see Luda is back. Luda, good to know you're back. And quickly here, apologies, you couldn't finish your train of thoughts there, but let me throw these in now. In your dealings with artists in the country, has there been any glitch or hiccups relating to foreign labels and some of these talents in Nigeria?
Not really. Basically, usually when artists get up to the level of discussing with a major, they usually have their legal framework already taken care of. It's usually a different level of conversation. And so for you to actually have, it depends on the kind of conversation you're having with the major anyway. Basically, some would say yes, depending on the level of deals that you're having with a major. Like it could be a distribution deal, it could be a licensing deal, it could be a recording deal. It all depends, and they give those kind of deals to the kind of artists, to a certain level of artists, basically. So on the mainstream level, there hasn't been any case I've heard of so far, but maybe down below there has been such cases, but I haven't heard of it.
Okay, let's bring in Tilewa to make this more clear for us. Tilewa, we're talking about a growing industry, massively growing and making incursion into other parts of the continent. How can these African artists, in this case Nigerian artists, get along pretty well with international labels?
That's a very vital one there. Now, talking about international labels, we need to really understand that, these are powerhouses, they are behemoths. They've been in the business for years. They understand it more than any other person. You talk about, the big threes in the world, the big labels, the majors, like you call them. Now, the majors have all set up, they have physical presence here all over Africa. And, they do that by signing several deals and contracts with existing structures here, in Africa. You talk about sub-publishing deals and licensing deals like you mentioned. But you see, the snag for us is because we do not have the proper framework. For instance, let me give you an example. Like the MME I cited, the Music Modernization Act, it talks about, a blanket license regime for mechanical royalties and payments for artists. In our own legislation, we talk about a compulsory license regime in the draft copyright bill. The United States have moved beyond the compulsory license regime to the blanket license regime, meaning that if you're an artist, the major DSPs, the likes of Spotify, the likes of Apple, the likes of Amazon, the likes of Deezer, will pay royalties to the artists. You're sure you get your royalties.
What's DSP?
That's digital service providers.
Good.
So you see, you have several layers. So these labels, these majors, they understand the business. So coming into Africa, they know that, Africa doesn't have a structure. For instance, they know that we do not have, for instance, in Africa, we do not have a unified intellectual property protocol. So essentially, pricing models are lopsided. So they could just come in here and sign anything with you and rip you off. But you will smile to the bank and feel, oh, great, I've made it.
Wait, so in as you put it, ripping off the African artists, is it, the absence, because in my thinking, the copyright law gives protection to the artist as the owner of the copyright, his or her contribution to the music product. And so whether or not they are coming, it depends on your ability to negotiate, right?
Yes, it depends on a lot of factors. Like I said, there ought to be, a certain type of knowledge, understanding the distinction between musical works and sound recording. Let me paint a live scenario here. Like if Sulai composes a song and Kemi is a great vocalist, Sulai is not interested in, adding vocals to the song, but Sulai is the author, but Kemi is going to perform the song. We are talking about difference right here. Sulai has, composition rights as the author. Kemi is going to put the vocals in the song. Kemi is a recording artist. But you see, we have, shifting cultures. We have producers now becoming songwriters, becoming, recording artists, and all of that. So it's very difficult to track these layers. So essentially, if you do not have an understanding of how this royalty splits, like split sheets, if you're a co-writer, 4 or 5 persons can co-write a song, and they will have different copyrights because they will have split sheet agreements that would determine the percentage split and what they're entitled to. And even a record label like the majors, they are coming, they understand these things, and they also want to protect their own end. So they know how to play dirty, and they know how to also fight dirty. So they are not going to sign a contract at their own expense, or a contract that will be disadvantageous to them, because they're into business.
And this is where you come in again, Luda, because sometimes it looks like some managers are the guide of these international labels, showing them the ways. But quickly here, why do you think these artists fall into this, such traps?
Okay, so it's the same thing. It's ignorance. Ignorance, basically. There are some things that the lawyer said that are actually very true. Like, they don't understand the intricacies between, like, the loopholes in the contract. There are a lot of having to read in between the lines, just in case. Now there are some contracts that let go of the copyright you're talking about. Like the labels get to own the masters of the songs, and they will be able to exploit it in any way. Basically, what I also understand, on the other hand, is our legal system here, as the lawyer also mentioned, isn't exactly the best, because we're still very much behind when it comes to putting a very good enough environment for creatives to actually explore their production freely. For example, it's still a case in Nigeria where if I compose and record a song, basically in Nigeria, under Nigerian law, I cannot remake that recording again. It is that original file. But everywhere else in the world, you can remake your albums, you can remake your, your singles as you like, if you're the owner of the actual copyright. But you don't have that right here in Nigeria. So it's actually very complicated when you bring all those factors in. And it still boils down to educating our artists first. There are different platforms all over Africa educating. There's the Music Business Academy for Africa. There are different platforms that artists are now going into to understand the music business, to take their careers more seriously, basically.
Right. So I just want us to talk about sampling for a bit, because then we've had conversations on social media about how a lot of artists have sampled without necessarily going through the process. So for you as an A&R, what would you say about the understanding of sampling in the industry?
Okay, it's actually a really big issue. You would have to, that's also legal. You would have to clear a copyright if you actually use one in your music. It could be a word, it could be a sentence, it could be a melody. We have at least Burna Boy made his public concerning the instrumentation of one of his songs in his last album, and how much he was also charged for that, and how much percentage he actually took for just that simple sample. So it's the ethical thing to do when it comes to creating music. If you use somebody else's idea, then you should at least credit the person for being able to create that idea. So you have to clear it. It means gaining permission. But usually people are blaming most recently in the industry, we're hearing the top dogs suing each other on rights, on different things. But I think it's still Nigeria, and it's still basically the growth of Afrobeats. Whatever the problem is, we understand could be solved behind closed doors. Eventually, it doesn't need to get up to the public scene. But on the other hand, it's just respect. You just have to respect someone's rights to their creation.
Well, talking about respect, let me bring it back, because Tilewa is still here. I'm eclectic when it comes to music and sounds, so whether old or new sounds. So the first time I heard Burna Boy's Last Lives, off the top of my head, I knew that there was Tony Braxton. He wasn't man enough, tune in that. So they called that a sampling. And for Tony, we understand that she said she got 60% of the streaming royalty, on that. How does this work, Tilewa? And what can the artists learn in having this kind of, should I say, collaboration, so to speak?
That's a good one. Now, let's make some clarifications here. For us to have a proper understanding of how this works, if you, like the initial example, the live example I referred to, if Sula has composed the song and Kemi is a recording artist, she lays her vocals on the song, you have composition rights. For composition rights, there can be only one composition. There can never be more than one composition. That's why you have the ISWC, International Standard Work Code. It's a unique identifier for every composition. So that never gets lost. But you see, for the sound recording, you could have 10,000. That's where sampling comes in. Meaning if a Dolly Parton does a song, I'll Always Love You, a Whitney Houston can come and jump on it, a Kelly Clarkson can come and jump on it, a Tony Braxton can jump on it, and they all, produce different variations to that particular song. But, the song retains its core originality, and the composition rights retained in the original author. That's how it works. So for, sampling, covers and all of that, you get clearance before you can jump on such songs. So they have an eligible framework and a standard structure in other countries. That's why you see that Burna Boy couldn't have even touched it without getting the clearance. And you see a lot of these artists, they have points. If you're dealing with, Tony Braxton will be signed to a major label, of course, and Burna Boy will have to approach the label, and that's expensive. So for an ignorant artist, you just pick up a song here in Nigeria and just go to the studio and sample off someone's song. That's an infringement. So, but a lot of people don't understand these distinctions. That's why I advocate for a lot of knowledge sharing. People really need to understand. There ought to be some massive enlightenment campaign for these young people, so that they can really know that this is serious business and not cock and bull.
Right. So and Luther, will come to you, but let's stick with Tilewa for a bit. For copyright owners, performers who have died, but their works are continuously sampled, like Fela Kuti, like Orlando War, like Oliver de Kock. What can they benefit, even posthumously? What is the benefit for them?
Yeah, that's the fundamental question. It all goes back to absence of, legal framework here. we need to up the ante in terms of, speedy passage of a robust copyright enactment that will take care of these issues. That's a very good question. If you look at other climes, for instance, in the United States, I go back to the MMA example, they have robust provisions to take care of their legacy artists. That even after they've stopped doing music, their estate can keep earning from the exploitation of their musical works or creative works, because the law specifies timelines. If you check the Copyright Act of 1976, it even has clawback rights. That if you've mortgaged your rights, probably due to ignorance or inequality of bargaining power at some point, over a certain number of years, you can claw back the rights, and it, you begin to enjoy, the fullness of the rights, again. So we've seen these provisions in the Copyright Act of the United States.
But in Nigeria, doesn't the country already have that?
We do not. That's what I'm saying. We do not. We are stuck in the rut. And you see, a lot of people don't know the dangers of this indifference. Because if we do not approach it critically, proactively, swiftly, then, we'll continue to work on opposite sides.
So what then does the law mean when it says that, for instance, if an artist dies, you can only use their work copyright free after 70 years, up to 70 years, I think.
Yes, that's just the duration of the right. Ordinarily, these rights are also, there's what you call the bright line or the balancing test. Nobody would claim rights forever. It's expected that the right, after you've enjoyed it for a number of years, it should revert to the government based on, provisions of the Constitution. It's just like patents too. Inventions, they are there for a certain number of years. You can renew, but at the very end, there's what you call the right of reversion, so that, members of the public too can access those rights without the fear of, infringement or, copyright claims.
So Tilewa, what you say now, if we were in an ideal situation, the artist would have been richer than what he is at the moment.
Absolutely. Absolutely. You take, for instance, the pattern of music consumption, keeps evolving. Now people sit in their homes, pick up their phones, and they stream music. And once they perform this act, royalties are generated. You have the all-in royalty pool, mechanical royalties, performance royalties, once you are handling your device. The question is, who's getting paid? Coulson and the likes, they're supposed to monitor these actions. And they should give updates to the artists in terms of, accounts. They should be able to render accounts. But these artists are getting nothing. So a lot of them will have to rely on tours and shows and all of that, just so that they can make ends meet and, keep their lives running. So you find out that, the artist and repertoire side of it, it's of keen interest to the artists.
So now speak to people like Aledeh and his entire team who are watching you today. How well can they stay afloat and reap, genuinely, legally, without being ripped off by anyone, be it record label or some producers?
Yes, we'll have to be very practical with that question, because the reality that we have in our hands is more like, it's in an inescapable consequence for us for now, except the policy makers get it right. Someone needs to take the bull by the horn. The lawmakers, they really need to sit down and understand that this is important, and it can become a power driver for revenue generation and to plug the budget holes. Because today we're talking about fiscal deficit and all of that, but we do not know the power that is in creativity. The surge of African soft power is what we should really capitalize on. Nigeria, for instance, is not a member of the African Region of Intellectual Property Organization, ARIPO. That's a very dangerous trend. Not being a member of ARIPO speaks a lot. It speaks a lot about the, lackluster nature and the non-committal attitude, of policymakers.
And Aledeh, before we let you go now, are there things you would love to see the National Assembly rejig, because he said, well, it doesn't look like there exists a law to better protect the artist and even, some others in the practice.
Okay, most of them, thank you very much for having me again, but mostly it's COSAN. COSAN has been a turn in the creative angles, the creators' life in the country, like especially the musicians. The issue that right now musicians have to register with different collecting agencies all over the world, other than Nigeria, because we can't even trust COSANs. The quarrel between the both of them, we don't really understand the situation, and even if you do, if you register with either, you're most likely not going to get your returns. So we have musicians registering outside the country to different other collecting agencies and being taxed on them. So it's quite a serious issue. Then also the case of investments. Recently, there has been a lot because of how big Afrobeat has been over all over the world. The world right now is listening to Afrobeat, most likely. So we just want more investment into the entertainment industry, mostly music, making a more suitable environment for artists to actually create. All over the world, we have grants, and we're hoping our government will be able to provide that for talent here.
It's a fine place for us to say many thanks, Luda Oruye, for being such a nice company, and of course, Tilewa Oyefeso, partner at Wigwe and Partners. Thank you for your time. And we really do hope that this conversation can can be sustained, so that until such a time that the Parliament in Nigeria and other African countries can actually look into this big business of entertainment and see how it can be protected specifically for the practitioners. Well, it's a wrap on the show. I'd like to say thank you for watching. I'm Sulaiman.
And I'm Kamini Amano. We'll see you again tomorrow, same time.